Kennedy is a job seeker. He is also a student at Zitech University. He hopes to become one of the best programmers in the country. In his motivated spirit and high dreams, he works in an office. The hiring manager is a well-dressed man that welcomes him. Fortunately or unfortunately,
he is by, and he was like, okay, why don't we do this? I was insisting. It came to a point where alikuwa anajaribu nikana nitisha ndio nipate job ndio lazima we smash, and he was guy. Like, to me that was nonsense, and for my sake it's either I stay jobless and I be comfortable being me rather than playing by his game, being his sex doll and stuff, for his own benefit.
Yeah, so did you tell him about it?
No, I never.
You never told him about
it?
But you felt
that was wrong.
What would you do different if you go back to that situation?
To be honest, I don't think I'll take further measures because, okay, if you have not made your way to me, I don't see why I should be falling, but it should be stopped.
But not everyone gets a chance to walk away. Winnie, a fashion stylist, had to live with sexual harassment for 4 years around her world of work.
My name is Winnie Ogutu. I'm a fashion designer as well as a fashion stylist. Actually, it was back in 2018. I used to work in a certain store. I won't mention the name, but mostly the staff we used to work with, it was all about men.
When did you know or feel that you recorded a sexual harassment?
The way those people used to look at me. Mm-hmm. Yes, when I was walking around the shop, some looks were not appealing to me. Mm-hmm. Yes.
Did you call them out for it?
No, those are clients. You can't call them out.
So did you ever tell your boss about it?
Yes, I did discuss it with my boss. Mm-hmm. But he didn't take any further measures about it.
Why do you think he didn't take any further measures? Did he give an explanation?
No, he didn't give me any explanation. I just explained to him whatever was going on, but he didn't take any action because I didn't see anything because the client they used to come the same way. I used to know it was a sexual harassment, because if you are well endowed, most of the time you get such behaviors from men. You can sometimes some used to tell me, I'm not here even to buy t-shirts, I'm not even to buy shirts, I just want to see your ass, and I didn't like it.
What are some of the comments that you felt that were so offensive to you?
Actually, some comments I used to receive, I used to find them very unprofessional. Mm-hmm. Some people would even suggest that you meet them somewhere, and those favors men want from you. Some will even touch you inappropriately, and I didn't like it. Yes.
According to the Kenyan Constitution, Section 23(1) of the Sexual Offenders Act, number 3 of 2006, it defines sexual harassment as continuous and unwelcome sexual advances, requests for sexual favors, lured verbal or physical gestures by someone in authority. As harrowing as it is, sexual harassment is a bitter reality that continues to break both public and private spaces. Subclause 2 of Section 6 of the Kenyan Employment Act mandates every company with 20 or more employees to make and implement a foolproof punishment plan for perpetrators of sexual harassment. Regardless of the setting where it takes place, sexual harassment is an acceptable act that calls for strict legal action. But unfortunately,
I didn't go to the police because our Kenyan police, when you go to report, actually they'll start laughing at you. And then also they'll tell you, "Ebu pinduka tuone kama ni ukweli."
Whereas most complaints are often by females about harassment by their male colleagues, it is important to note where there is consensual relationship, the policy should not be used to settle scores between two people who have since disagreed. This poses a challenge when cases are presented in court.
Sexual harassment has been giving us a challenge in the courts in terms of protecting victims due to the various gaps and challenges that are in the laws. You will realize from our laws that the Sexual Offences Act only speaks about persons in public office and persons in authority. The Employment Act under Section 6 only covers employees who are in formal workspaces, that means offices, and it has to be an organization that has over 20 employees. That is where the employer is obligated to have a sexual harassment policy. And this makes sexual harassment very difficult to prosecute in court, and many victims have been out there suffering without means for justice because the laws as they are have not sufficiently covered them. Work has changed in the way we know it. There are many forms of work. There is a whole informal work sector. There are persons who do casual work. There are outsourced workers whose workstation is not normally where their employer is stationed, and so they're exposed to sexual harassment from other people who are not within or under the direct control of their employer, and therefore seeking redress for victims of sexual harassment in these instances becomes very challenging within the current legal framework, as much as there are also other international instruments that could be used. Most people are not aware about what they could do in such instances. We also have gaps within the reporting mechanisms because we know the challenge of presenting evidence for sexual harassment. Mostly it takes place in private spaces, and therefore it becomes an issue of she said, he said, and therefore many victims, both male and female, are suffering without redress. However, we are in a new era where there's the International Labour Organization has passed Convention C190 that talks about violence and harassment in the world of work, and this is a more holistic approach towards addressing gender-based violence and harassment in the world of work. Some of the challenges that I have encountered in terms of trying to seek justice for victims is one, the challenge of presenting evidence, two, the challenge of helping the police or prosecutors understand how sexual harassment manifests, and one of the other great challenges is the myths, misconceptions, gender stereotypes that exist within our society as it is now, and these are prevalent from all stakeholders and all duty bearers, whereby they are blinded by those stereotypes and are not quite able to understand where the victims are coming from and what redress they would need. And I would say the biggest challenge is the presentation of evidence, because people are not able to understand how sexual harassment manifests, and that it is as a result of power imbalance between the abuser or the perpetrator and the victim. It is also quite challenging for victims to keep speaking about it, because even when they have witnesses, those witnesses are not willing to come forward for fear of victimization. And you will find that we have a culture, especially in Kenya, of blaming the victim and shaming them for whatever it is that they underwent, rather than empathizing with them as a victim and seeking to protect them.
Although the international labor law by the International Labour Organization ILO mandates each member state ensures a sexual harassment-free work environment, the Kenyan government is yet to sign the Convention 190, otherwise dubbed as C190, which is more elaborate on the world of work and employee protection, as Jackie Nganga, a convener of the Political Feminism Working Group, explains.
Convention C190 is an international labor organization convention passed in 2019. It looks into the issues of violence and harassment in the world of work. It is important because it covers the legal gaps in our Kenyan jurisdiction. The laws and the policies that we have in place are not sufficient to deal with issues of violence and harassment in the world of work the way C190 does. So the convention has a broad definition of what violence and harassment in the world of work is. It covers workers irrespective of their employment status. It covers workers both in the formal economy and the informal economy. It looks at workers who do casual labor, domestic work, shop stewards, and people who are working in different areas and sectors in the world of work. It also defines the world of work in a wide range, especially not only looking at a designated workspace, but also looking at the issues and the activities that lead people to work in the world of work. It covers platform workers, people who are working at the home environment, people who are working in the matatu industry. It covers commute of an employee from home to work. It covers employees who are on work study. It covers employees who are attending conferences. It also covers employees who are on staff retreat. It covers job seekers and interns as well. So it gives a wide coverage on violence and harassment in the world of work to diverse groups of people. And it also looks at vulnerable groups, people who are marginalized, the sexual minorities, and also persons who have disability. It is important for Kenya to ratify the convention because of the different provisions that it brings to light in terms of protection of workers in the world of work. It also looks at the violence and harassment in a wide range, and especially because most organizations will have a sexual harassment policy, but the violence and harassment in the world of work is more than sexual harassment. And most organizations only have the sexual harassment policy. The Employment Act mandates organizations with 20 or more employees to have a sexual harassment policy. But we are aware that most organizations have less than 20 employees, and if they are not mandated to have a protection mechanism or a sexual harassment policy, then it exposes many employees to abuse and harassment. The other issue is the components of those sexual harassment policies is not necessarily defined, because some of those policies neither don't define what sexual harassment is, and if they define sexual harassment, you'll find that some of them don't have a clear reporting and complaint mechanism or a follow-through process from when the complaint is made to when a decision is made, and the different decisions that can be made and the implication on the person who has perpetrated the harassment. So it is important for government to ratify Convention C190 to bring a wider protection of employees and workers in the world of work. The convention was ratified in the year 2019, and it came into force after Uruguay and Fiji had ratified.
Are you able to compare some of the acts that are on the convention and are not in our constitution?
So not necessarily the constitution, but the different laws that we have. For example, when you look at the Sexual Offences Act, the Sexual Offences Act talks about sexual harassment, but that's not the only form of harassment that happens in the world of work. So the Sexual Offences Act talks about sexual harassment. The Employment Act talks about organizations with 20 or more employees having a sexual harassment policy. But when you look at violence and harassment in the world of work, it is more than sexual harassment. We need to look at the emotional safety of workers. We need to look at the safety of workers from a physical perspective, whether they have protective gear, whether they are getting their salaries and wages on time, whether they are paid for the kind of work that they are doing. So the convention gives a wide range of protection mechanisms for workers that the national laws don't.
So far, 28 countries have ratified the convention, 7 of those countries being from Africa. During last year's Generation Equality Commitment, the former President Uhuru Kenyatta gave a commitment that Kenya will ratify the convention by 2026. Reporting for The Voice KE, my name is Collins Wangoi.